My name is Anthony Tharp, and today is December 13th, 2022. And I'm here making this video so we could help to expose a lot of corruption that's going on in the Jamaica judicial system. Now, corruption is not only in Jamaica. This is a case that's been documented since 2010. 2010, when a lawsuit was filed against us. And when we won the case in 2012, and the Jamaica Appeals Court ruled in our favor, ruling that the losing side, which was Capital One NA, the 10th largest bank in the United States. Now, we won the case, but what took place after still hasn't gotten to a lot of people about the corruption, and that's evident in a lot of the rulings that came out of the court since. Now, I want you to understand this is not just some conspiracy theories. This is actually events that we experienced, and we are part and parcel of the whole corruption that affected not only myself, but my joint venture partners. And in fact, the level of corruption, which runs into billions of dollars, has done significant damage to the Jamaican economy. This matter is much bigger than I am, and so it's important that I take the time to share it. A number of recent events prompted me to make sure I get this message out, because it's important. And unless we fix these issues, I'm afraid my beloved country of Jamaica is going to end up like Haiti, a failed state, because of corruption that's ongoing in this country, and from places that we would not think it should happen. In fact, we have given members of the judiciary more power over us than any other arm of government or government agency. And yet that's one of the agencies in this country that has never been audited. And yet we know there are corruption issues that have been documented. In fact, the Privy Council, I think maybe 3 years ago, mentioned that some of the worst rulings coming out of the Jamaica Judiciary is what they've been encountering. I mean, worse than anybody else. John Kerry, Secretary of State of the United States, said Jamaica has the most dysfunctional judiciary that he has ever encountered. And so it's important we address it and don't pretend it doesn't exist. And some people might think it's offensive for us to, or for me to be critical of the judiciary. But in reality, I'm not catching on this planet. I'm Jamaican. I'm born Jamaican. I live here. I travel, and I invest a lot of my time and energy and money here. So I have all the rights in the world to say what I'm going to say. And I believe that Justice Sykes, the Chief Justice of the Supreme Court, needs to take heed and resign his position, because the buck stops with him. And I'll say this because I'm going to detail issues that arose in this matter. It's a 2010 HCV 02692 claim that was filed against me and my partners. And we were doing a development in Montego Bay, possibly the largest real estate development on the island at the time. We got our approvals from NEPA, and in 2008, and in 2010, here comes Capital One through Trevor Holin, who filed a lawsuit on behalf of Capital One, alleging that they had an interest in the property that we're developing on 15 Queens Drive. 15 Queens Drive is significant because I have created the theme, the fence that broke the scammers back. And why I'm saying that is I was ill like 2 weeks ago, and somehow I had to call the courthouse, the Supreme Court, to let them know I couldn't attend court in certain matters. And before the week was out, agents of people from Kingston came down, surveyed my property, fenced the property, and told the residents there that they had to get out. Now, they claimed they had orders from the court. There were no such orders. But what has been going on is that certain members of the judiciary and officers of the court, namely John Graham an attorney in Kingston, Alexis Robinson from Miles Fletcher and Gordon, over the last 8 years have been pushing an agenda of fraud to defraud us of the property. Now, most people might say, why would attorneys be doing this? Obviously, we know it's a common practice because a lot of attorneys have been going to jail of late. And I've been pressing the Fraud Squad, the Integrity Commission, the Judicial Service Commission. I've reported it to the JCF, the Commissioner of Police. I've written documents to the Governor General, the Prime Minister, the Minister of Justice, and we've pointed and provided evidence of the ongoing fraud. In fact, why I raised the issue or mentioned Justice Sykes was before Justice Sykes became the Chief Justice, we had a CMC, a case management conference, in which Justice Sykes appeared. And I asked Justice Sykes to grant an order so that this JCF could investigate the fraud that was ongoing. Now the JCF, oddly enough, said they needed an order from the court to investigate fraud in the court. So we filed to get the justice to grant an order. He said he wasn't going to do it. In fact, what he said, if he did it, a lot of people would get into trouble. I mean, that shocked the heck out of me, prompting me to file a complaint with Chief Justice, then Justice McCullough. I filed a complaint with Mark Golding, who was the Minister of Justice at the time. So everything I'm saying to you is documented in the court's records, and it's not being made up. I'm saying everything that you have an access to go and check for yourselves. It's a public record. It prompted me to go even further and file charges, fraud charges, in the United States with the FBI, the Comptroller of Currency, the Attorney General of the U.S. Attorney's Office. So this documented corruption is something that could be easily verified by anybody that's interested in doing so. And in a couple of weeks, and before the Christmas, we'll be uploading on Amazon details of documents. We're going to scan those documents and put them online for you. If you're interested to go and check the facts, you could go to Amazon and just research the fence that brought the scammers back. Because this is one of the biggest scams that's going on in Jamaica, because it's costing Jamaica over $4 trillion over the last 14 years. We started our development efforts in 2005, got our approvals in 2008. By the time we got to 2010, here comes Capital One through their attorneys here in Jamaica, claiming they had an interest in the property. In 2012, June of 2012, the appeals court threw out their case and said they had no standing, no claim, no interest in anything. They didn't even have standing to be in Jamaica because they are not a company registered in Jamaica and had no assets here. So after the appeals court ruled, the judge who was the lead judge at the time, Mr. Justice Brooks, indicated that they could not dismiss the claim because my attorney did not ask the court to dismiss the claim. So the only way the claim could be dismissed was for us to file another application in the lower tribunal, which is the Supreme Court. So after that ruling by Justice Brooks in June of 2012, we went back to the Supreme Court. And when we went back to the Supreme Court with one intention, to get the claim dismissed, unfortunately, when we filed all the necessary documents, we appeared in front of the courts. Here comes John Graham and company saying they're now representing Capital One. The first thing they did was the court granted them an injunction against our projects. Now, if the appeals court already ruled that these people had no stake, no interest, no claim against anything, why would any judge give an injunction against the party, the successful party? But that's what happened. When we challenged it and came into court, we came in front of Justice Mangatal. I think she's now in Cayman. Justice Mangatal told us she's going to continue their injunction, and because she didn't have the files, and so she continued the injunction, and this kept on going for about 5 months, we came in front of several justices trying to get the claim dismissed. It never happened. And what happened next was that John Graham issued through Capital One to the Supreme Court of Jamaica an undertaking to pay us damages for what was going on in terms of the injunction. So any damage that resulted as a result of the injunction, we were to be paid damages. So Capital One gave the Supreme Court an undertaking to pay damages. Now what that means is that any damages that was done to us, Capital One was mandated to pay. It was a binding undertaking. What happened next was that the files disappeared and kept disappearing. It got so bad that we had to petition Justice the Chief Justice at the time was Justice McCullough, yes, and she had to recreate the files 3 or 4 times, then put them under what is called security lock. That resulted in a significant delay of events. We then proceeded and pressured the justice to set the matter for final judgment because we were there for that and that alone. Eventually it came up and she assigned a Justice Beswick, Lawrence Beswick, who ruled on the matter in 2015, the 29th of May 2015, where she definitively again reinforced what the appeals court had said. And John Graham jumped up after the judge said the claim was dismissed and said he didn't understand what was going on. So the judge said she was going to clarify it. In December of 2015, the judge came back with her clarification. Now if you look from May to December, that's almost 8 months that we've been delayed again on moving forward. On the 24th, Justice Beswick, Mrs. Justice Beswick came back again, gave her final judgment and told John Graham, who was representing Capital One, that they not only owed damages, but they were mandated to pay damages under the undertaking they had given. The problem was that now Justice Beswick also ruled that they could only file an appeal to the appeals court. What John Graham did was in January, less than a month after that ruling, in contempt of those orders, he went ahead and filed another claim under, this was 2016, HCV 0064 claim, using an employee of Capital One, a Lorraine Gallagher, to now file that suit under that another claim seeking the very same remedies. But in the caption of the claim, it does say Lorraine Gallagher representing Capital One. Now the appeals court had said they had no standing. So what John Graham did, John Graham went and applied in another claim, didn't notify anybody about that claim, that he wanted to apply to appoint Capital One administrator for an estate that we had bought the property from. Now this estate is a New York estate. The parties the deceased was based in New York, lived in New York, died in New York, was not Jamaican. And so he applied to appoint Capital One as administrator for an estate that was fully probated and settled. Now when an estate is settled, it means it's closed. Nobody else can go in and claim anything, or it's settled by the Surrogate Court of New York. So what transpired now is one of the events that showed us that corruption was alive and well in the Supreme Court. So John Graham filed his second claim under Lorraine Gallagher. Then they went and filed another claim that we knew nothing about and appeared in front of a Justice B. Morrison. Now Justice B. Morrison gave orders appointing, this was in September of 2013, appointing Capital One administrator for an estate that doesn't exist. They took that appointment, then went back to New York, or to Florida, where we're from, and stated that no, the Jamaica courts had appointed Capital One trustee for an Alexander Burnham trust. Now I hope you're paying attention, because so Justice B. Morrison appointed Capital One administrator for an estate that was fully probated and settled by the Surrogate Court of New York from 2002. This was 2013. Then Capital One, through John Graham, with Capital One's attorneys in Florida, where we reside, went and filed a claim in the Florida courts that Justice Morrison had appointed Capital One administrator for a trust, and they are now trustees for that trust. Convoluted as it sounds, that's what happens. And as I said, you'll be able to check the documents yourself. So that was the first, one of the major indications of fraud in the court, where Justice B. Morrison went ahead and appointed somebody he didn't have jurisdiction to appoint as administrator for a New York-based trust and estate that was settled in probate. Then Justice Morrison is important because, and we'll get to that, but just a glimpse of what happened. We were successful, as we said. Eventually, we got the matter set for assessment of damages. This was in 2016. Now, Capital One kept filing these fraudulent claims in the court, and we kept pointing them out, and nothing was being done by the court. The files would disappear. So in 2017, I filed what is called a voluntary Chapter 7 petition in a U.S. court in Florida. That's a voluntary bankruptcy petition. And automatically after filing that petition, the debt collector must cease and desist instantaneously. So I filed it to stop them from pursuing any further collections effort against me and my partners so we could go on with our project. So they took the appointment that Justice Morrison made, went to the Florida courts in 2017 and filed now that the Jamaica courts had ruled against me on 2 occasions, and I owed the Alexander Burnham Trust $600,000 US. Of course, that's all fraud and was made up. Then they filed in the bankruptcy court that they were going to now get the bankruptcy trustee, my trustee, Mark Yu, to settle the debts that I owed them by taking over the company that I owned and had the project approved and on the property at Queens Drive. And where Justice Morrison is important here is that we had the matter set for damage assessment in January, on January 29th and 30th. On the 29th of January 2019, when we appeared in court, in open court for the assessment of damages, here comes Justice Morrison, jovial and laughing and saying he didn't have to hear anything about damages because we had withdrawn our right to damages. Of course, we were in court with attorneys and there were other people in court. So again, this is verifiable. I said to Justice Morrison, if we had withdrawn the damages, why would we be in court? Apparently, Alexis Robinson from Myers, Fletcher and Gordon was retained through John Graham and Capital One, claiming they owned my company, a Business Ventures and Solutions, Inc. Now, Business Ventures and Solutions, Inc. had nothing at all to do with the development. So they believed that Business Ventures and Solutions, Inc. was entitled to damages, and the damages that we were owed for the damage on the project. That was not the case. But nonetheless, Justice B. Morrison refused to hear the matter on damages. Said the damages were withdrawn, and regardless of how we spoke or addressed the court and said we didn't withdraw it, here we are, and there were attorneys representing my other partners, he said he didn't want to hear anything from us. He didn't even adjourn the matter. What he did, he said he didn't want to hear anything from us and moved on. So from January of 2019, we have been trying to get the assessment of damages reset. We filed applications after applications, before multiple judges. And to date, John Graham, Capital One, has been filing and getting their matters heard and we cannot get the matter on our assessment of damage reset. Now, why is the damages so important? Because Capital One gave an undertaking to pay us damages, and they gave it from their corporate offices in the state of Virginia. Now, Capital One has no assets in Jamaica, which means they can do anything here and flee the jurisdiction. And the Jamaica courts couldn't do anything about it. But they gave an undertaking issued from their corporate office in Virginia. So we need a final order from this court so we can domesticate the judgment in the United States, in Virginia, so that we can go after Capital One for our damages. Now, in order for us to collect our damages and avoid any prolonged litigation, again, we need that final order. And that spells the second event that's telling us there's widespread corruption going on in the court as it relates to us and possibly other persons. Now, as I said, from 2019 until now, 2022, going into 2023, we can't get the assessment of damages reset, even though the damages were filed. We had asked the court to appoint expert witnesses, and a Justice Batts appointed 2 expert witnesses who calculated that we were due damages in excess of 20 billion US dollars, because we're doing a major real estate development with franchises across the island. As I said, all of that is on the court's records. And when you factor in interest from 2010 until now at 25% or even less, it's significant. So we've been waiting to get those matters settled in the courts, and the court is refusing to set those matters for hearing. Now, one of the strategies we used, I decided, you know what, to avoid any issues with Business Ventures and Solutions, again, which is a company they tried to take over. And the takeover was done in the following manner. They went to the US bankruptcy court. They got my trustee to accept a fraudulently filed claim that I owed $600,000 US to the Alexander Burnham Trust. Then my trustee got paid $55,000 US to settle the debt, all the debts and claims I had against Capital One for that $55,000 US. Then he turned around and got an order from Judge Hyman in Florida at the bankruptcy court that they were going to sell my interest, my 100% interest in Business Ventures. So when they allegedly acquired my 100% interest in Business Ventures and Solutions, it meant now that they could say they own Business Ventures and Solutions. Little bit known to them that when that transaction took place in October of 2017, all the assets and interest in Business Ventures and Solutions were already sold and transferred from August of 2017. Now, why that's significant? Again, because we've appeared in court hearings after court hearings, and we've presenting those documents to the court, and the justices in front of which we come completely ignore the fact that those sales transactions took place in 2017 of August. And instead of honoring the transaction that was legitimately done and recorded in the Supreme Court, they've completely ignored our sales transaction. And every time Capital One, through John Graham, appears with this fraudulent sale in October, they've honored it. So what has happened is that Capital One has used about 3 of its employees to keep refiling claims. Now, in 2018, John Graham, using that US purchase of Business Ventures and Solutions or the court, and came in front of the Supreme Court and applied to the Supreme Court, asking the Supreme Court to decide whether I could represent Business Ventures and Solutions or represent myself in that capacity. Now, in May of 2018, May 16 to be exact of 2018, the matter came in front of a Justice G. Brown. And Justice G. Brown looked at the documents from the US court including documents that the Supreme Court of Florida said they have no jurisdiction in the matter. He looked at the fraudulent sales transaction that took place in October of 2017 via the trustee, my trustee, the Alexander Burnham Trust, Capital One, their U.S. attorneys in association with John Graham and the attorneys here in Jamaica, who sent affidavit after affidavit from this jurisdiction to the U.S. jurisdiction in support of their fraudulent moves. So when Justice G. Brown examined the entire files, he ruled that not only could I represent the company, but he was making sure he was going to put in the order that he was going to recognize me as the representative for Business Ventures and Solutions, Inc. in this court's jurisdiction. Now, immediately after that, Justice G. Brown set the matter for hearing in January of 2019. He also set July 4th of 2018 for what we call interim payments and remedies, because the damages were so enormous that the rules of the court are when damages are excessive, then the judgment creditors are entitled to payments prior to settlement of the final numbers in damages. So he set that for July 4th, 2018. When we appeared in 2018, July 4th, we came in front of a justice, I think Miss Justice Henry Mackenzie. Now, when we came in front of her, she said first of all, John Graham went and said to the judge, oh, the matter of representation was not settled. The justice looked at the order and said, Mr. Graham, that is not the case, because the judge not only appointed Anthony Thorpe recognized, but he set the matter for damage assessment, which means the matter was settled. So Justice Henry Mackenzie proceeded to make orders to include the purchasers of the August transaction 2017 of Business Ventures, who became the successors in interest of the damages that belonged to Business Ventures and Solutions. Unfortunately, we didn't have the files in front of us, and the files from the registrar or registry didn't get to the justice in time. And not wanting to put errors in the document, the justice set the matter. CMC adjourned it to November 25th, 2018, where that was dedicated to putting the persons who had acquired Business Ventures and Solutions in place and removing Business Ventures and Solutions. When we came to that hearing on November 25th, 2018, the matter appeared in front of a Justice K. Anderson. Justice Anderson decided that he had just gotten the files the Friday before. I think this was a Monday or a Tuesday. And therefore, he wanted more time to deal with the matter. I said to the justice, this is a matter of substituting persons. Capital One had no say in the matter because the damages and the assessment that was determined already, and assessment of damages set. Justice Anderson said he wasn't going to do it. Now, one of the reasons before Justice Anderson, Justice Henry Mackenzie had set the matter to be heard on the 25th was because we have assessment of damages coming up in January. And she said she wanted to have that done prior to the assessment of damages, which made sense. So when Justice Anderson did that, I said to Justice Anderson, well, you have to get an early date so that the transaction could be completed in registering the persons who are really entitled to damages, because there were different parties and each party had a different outlook in terms of what damages they were due. Instead of setting the matter before the assessment of damages for January, Justice Anderson set the matter, I think, for February or March in 2019, which meant this would take place after we had a hearing and assessment of damages. So when the matter was coming up in January, we decided, yeah, let's go ahead, because we could remedy that without complicating things for the persons who were entitled to damages. So we set out to go to the assessment of damages. We filed memorandum of damages and the amount of damages that was due to us at the time, and it was significant. So apparently between, I must back up a little, on November 25th, when we appeared at CMC, Miss Alexis Robinson from Mass Fletcher and Garden showed up, said she was representing observing matters on behalf of Business Ventures and Solutions, Inc. Now remember, Business Ventures and Solutions, Inc. was already sold in August of 2017 to the parties in interest that Justice Henry Mackenzie was in the process of substituting for Business Ventures and Solutions. Now, Capital One's so-called acquisition of Business Ventures and Solutions took place in October, and I must point out that they didn't truly acquire Business Ventures and Solutions. What they said they did was they acquired 100% interest that I owned in Business Ventures and Solutions. And as I've said before, not only were they completely off, because I didn't own 100% of Business Ventures, and at that point in time, I didn't own any part of Business Ventures and Solutions, Inc., which means they purchased 100% of nothing, which is zero. That didn't stop John Graham, Capital One, Alexis Robinson from appearing at the 25th of November CMC, where she said she was observing on behalf of Business Ventures. We told Justice Anderson that we didn't know this woman, we didn't retain her, we didn't know why she was there, and we wanted her gone. He said he was going to allow her to stay. So that was the first time we encountered Alexis Robinson. In January, said she showed up again, because on the 28th of January, she apparently went the evening before the assessment of damages and filed a withdrawal notice for damages for Business Ventures and Solutions, Inc. Now, why Justice K. Anderson is significant in this whole corruption scheme is that he deliberately set the matter to be heard, to set the matter to appoint expert witnesses after the hearing in January. And when we did come up for hearing on the assessment of damages, Justice Morrison conveniently had the occasion to say, well, the damages were withdrawn and therefore he wasn't going to hear anything from us. It's just too much coincidence. Then in, I think it was February, when we did have a hearing on substituting the parties, Justice Anderson said he wasn't going to do it because we withdraw damages. So I hope you see the correlation, that these aren't coincidences. These were calculated effort by these justices to ensure that we don't get to collect our damages. Now, that is the matter that we're faced with and have been faced from 2012 until now, where justices come into the court and they just blindly disregard us and keep allowing Capital One, through John Graham, Alexis Robinson, to keep appearing in these matters. Now, after we made an effort to give the justices the opportunity to correct these errors, including Justice B. Morrison, Justice B. Morrison only said to me he had told me to get an attorney, and he wasn't going to review what he had done or reset the matter for hearing. Now, apart from that, files disappeared. Alexis Robinson kept appearing at CMCs on behalf of Business Ventures, alleging that she was representing Business Ventures. Now, the kicker is that when Justice G. Brown made his ruling, we raised issue in several case management conferences to say that Justice G. Brown had appointed me, Anthony Tharp, representative for Business Ventures. So why is Alexis Robinson appearing? And regardless of how often we raised the issue, there was no appeal, there was no withdrawal of the orders, which couldn't be done because they had to appeal to the appeals court for that to have happened. And I think it was Justice Phillips in the matter of Bartholomew Brown and Bridget Brown that ruled that courts cannot review their own decisions. So we've been asking since 2018 until now, why is it that the Supreme Court keeps allowing these persons from Capital One to appear in matters that they have no standing, that the court already ruled that the representative for business ventures is this person, Anthony Tharp. And so what happened next is even more shocking. Alexis Robinson, because they've been trying to take the property from us. They tried to sell the property after Justice G. Brown made his ruling. Without notifying anybody, no orders from the court, the 15 Queens Drive property came up on multiple listings by Remax. A realtor called us to say, Anthony, you're selling the property, you didn't tell us anything about it. That's how we found out. So we contacted the lady at Remax, Nicola Della Pena, and we said to Nicola Della Pena, we don't know what transpired, but certainly we didn't ask for a property to be sold. Could you withdraw it? She refused, in fact, telling me I had to get in touch with Alexis Robinson, attorney from Myers, Fletcher and Gordon. So we sued her as well. We're still trying to find her to serve her the summons. But that's the nature of corruption. So she's going to tell us she's not going to listen to us. We had the property removed because we contacted Remax International and told them we were going to sue them. And so eventually that property came off. And this wasn't the first time they tried it. They also had the property listed prior to that with Century 21, I think it was. And we had the same thing, conversation with Century, but they pulled it. So when that didn't work, and they had to withdraw the sale of the property, we now found that Alexis Robbins filed in the Supreme Court that I was trespassing on my own property, and property that I had development permits to develop one of the largest real estate development projects. We were in possession of the property since 2005. And Justice G. Brown, to a question raised by John Graham in that CMC of May 16, 2018, when he talked about possession, Justice G. Brown told him, even if we didn't have papers for the property, we couldn't be dispossessed of the property because of squatters' rights, the Limitation Act under the Constitution. That should have ended that. But instead of ending it, Alexis Robinson filed a complaint that now I was trespassing on my own property and took out an injunction that was supposed to stop me from accessing my property. Now I don't know how that's going to work because it was illegal in the first place for a judge to even give that injunction. One, Alexis Robinson had no authority. Two, Justice G. Brown had already ruled on the matter of ownership and possession of the property. And so we were shocked when we were told that this application was in. We filed all the necessary documentation, all the necessary paperwork, including paperwork from the U.S. courts that says U.S. court has no interest or jurisdiction. And yet, the judge who heard the matter granted an injunction. So apparently, I was being restricted from going onto the property because we were defacing the property, even though what we were doing on the property was actually executing measures to develop the property. I was not supposed to have anything to do with the property. And this is after almost 14 years of litigation. When we filed objection and the matter was not being set, I ended up in November. I don't know if you know, and I'm going to get personal. I ended up in November doing a colonoscopy. And I'm on blood thinners. So when they did that, they withheld my blood thinners for 7 days. Now, immediately after I did the colonoscopy, I went back on my thinners, but it was too late. So I suffered a blood clot which rushed to the back of my eye, and it was a mini stroke. So I had to call the court to let the court know that I was unable to attend court on other matters. Within less than a week, of that announcement, somebody from the court got in touch with Miles Fletcher and Gardner, Alexis Robinson, and John Graham, and sent people down to the property to survey the property, fence the property, and chase or throw off the persons that were authorized to be on the property. All illegal moves, because somebody thought I was either dead or undying. Unfortunately and foolishly, I don't know how people like this could think that way, because in major developments like this, where we have partners and we have special interests with interest in the project, you think it's only me that they have to contend with. So they figure I'm dead, so they're coming to snatch the property, which again is illegal. And I'm saying this so that Jamaicans can wake up and realize what's going on. Now, why this is important? Because the project we're doing would have created 500,000 jobs across the island, because we're franchising different locations. We were bringing in infrastructure and entertainment for the tourism sector. We had petitions signed by hotels on the strip that they could share in and use our facilities, because we're bringing in attractions. We're putting an iconic structure on the property, meaning we initially were going to put a 21-story tower, but we decided in consultation with several, and I'm going to use the word stakeholders, even though I don't like it, with persons who had an interest, that we're going to do an iconic structure on the property. So we actually started to have discussions with the permitting bodies to do Jamaica's first high-rise skyscraper, a 125-story mega structure that would have put Jamaica on the map and brought in tourism dollars to the economy. Now, during construction, we're talking about 6,500 workers. We had sites set for 32 restaurants. We had retail sites for upcoming artists and designers. So, and these are projects that were already being advertised. So the reality is, we need to address the corruption that's going on in the court. This is not coincidence. And I'm saying this to you that even as we speak, and we've petitioned and sent letters after letters to the registrar, to Chief Justice Sykes, and we've CC'd everybody in the court, so everybody knows about this. You can go down there and ask them. There's no secret. We CC the JCF every time we've sent in correspondence to Justice Sykes or the court. We CC the JCF, because we want people to know that we have to stand up as Jamaicans if we are going to correct the ills that's going on in this country. Now imagine, this is the most important institution in this country. It has never been audited. And even though we are conscious of the fact that corruption exists and is ongoing, nothing has been done. Nothing. If it was a secret, then we could say, fine, we don't know. But unless we fix it, even the great United States, in the last couple of days, Congress is now having hearings on coming up with new strategies to deal with the justices in the court system, because we can't trust these people to guide us blindly, because they are selfish, greedy, and corrupt persons who have no interest in serving the judicial process in the way it should be. They have allowed John Graham to have the run of the courthouse, and Capital One, who is undermining this country, has been able to get away with the most outrageous levels of fraud in this court that we've ever seen, and we might never see again. But the important thing, this is the most documented case of fraud that exists in Jamaica. And it doesn't exist here in Jamaica because, remember, Capital One is a US-based mega bank. And so they're fighting tooth and nail not to pay us our damages. So they keep reviling issues in the Supreme Court, which the rules of the court say they are not supposed to. They have acted in contempt of the appeals court. They have acted in contempt of justices of the law of the Supreme Court. And yet we can't get the court to even set the assessment of damages so we can conclude and get on with our lives. We have been held hostage in the Supreme Court by capital one. We are virtual prisoners of the Supreme Court, and we make no qualms about what needs to be done. Justice Sykes needs to resign and clean out that courthouse with all the persons he's aware that's involved in the corruption. It's not coincidence, it's a crime, and we must fix it. So I say again, in another 2 weeks of you viewing this, we're going to be releasing stuff on Amazon under the title, The Fence That Broke the Scammer's Back. Now, it's not hard to fix the court system. It's very easy. Just we need to have oversight, independent oversight, and weed out the judges. And I generally say judges, but we know they are clean, professional judges that operate in the court system. But you know what? If you, as a judge that wants to do your job and your duty to this country and the people and the citizens of this country, sit quietly and allow this to happen, then guess what? You don't know better. You're just as bad because you allow corrupt judges to smear you. And then you expect the public and people to keep quiet about it. Now, I'm willing to go as far as saying that we are going to start working on our development come January. We are going back into the marketing, redesign the structures, do new renderings to do the marketing process. And I'm going to do something that has never been done anywhere. I'm going to tie the development into fixing the corruption that's going on in the court system. And this corruption can be fixed if officers of the court, members of the court staff start identifying, become whistleblowers on these people that are doing all these corrupt acts. I am prepared to tie in and saying it publicly that I am prepared out of the development to pay anybody or persons who jointly work together to solve this problem, expose them, send it to the press. And the press has been very quiet on this, by the way. $1 million that we will pull from our profits of the project to pay to anybody that steps forward to solve this problem. We will also contribute from our profits from the development $5 million to revamp the court system with all kind of regulation and oversight to ensure that Jamaicans aren't treated the way we were treated when we were dragged out of Africa, because this is what's going on. Our rights are being usurped by corrupt persons. A U.S. corporation that has no interest in this country can just show up, go into the Supreme Court and do whatever it wants, and nothing is done. As I said, the Prime Minister knows about it. We wrote to him. The Commissioner of Police knows about it. The General Legal Counsel, by the way, when we filed complaints about John Graham, they said they didn't say anything wrong with him. Even though when we went to the DPP's office and we asked staff there, is this fraud or isn't it? They said it's fraud, but they need the JCF, the fraud squad, to present them with a folder. That hasn't been done. So the reality is Jamaicans need to stand up. I'm doing this because I'm on my way out of here anyway. But we have young people coming up that don't need to go through this. They need to know that they can trust the system and put their trust in a judiciary that will guide us along a path where we don't have to go through all of this mess. Crime is rampant because we have corruption. And it's not only corruption in the JCF or on the streets or in local government. The judiciary is corrupt and it must be fixed. I want to thank you, and I hope you understand what this is about. It's not about me. I didn't need to do this. I could take my little pennies and go by myself someplace and forget it. But it's important that Jamaica solve this problem. It's not enough for Jamaicans to sit on the sideline and think somebody else is going to fix it. You have to stand up, and ignoring it is not going to help. It's going to come back and bite you where it doesn't shine. The sun doesn't shine if you don't fix it. Thank you very much. And please take the time to go and review the documents. Go to the courthouse. I'm giving you permission to go and pull any documents I have filed in the court. So it's publicly said, I'm giving you permission to go to the courts and pull those documents. As for the press knows about this. We've been trying to get the press since 2010, 2012 to expose the fraud. Initially they told us they have to wait until it comes out to the court. When it came out of the court and we handed them a dossier that thick, we were told that higher-ups didn't want this to be published. Seriously. I want to thank you, and I hope this makes a difference in our lives. Have a good one.